Welcome to Casa Academy Chapter 9, Part 1, where we will cover title, deeds, and ownership restrictions. The concepts we're about to unpack today, they are literally the absolute bedrock of your real estate career. If you want to truly master this industry, you absolutely have to master these fundamentals first. So let's get focused and dive right in. Here is our agenda for this explainer. We're going to cover 1. Understanding real estate title, 2. Transferring ownership with deeds, 3. Government and private restrictions, 4. Property leases and liens, and 5. Our core chapter takeaways. Section 1. Understanding real estate title, the foundational concept of ownership. Okay, so in real estate, title isn't actually a physical document. It's the invisible legal rights associated with ownership. And a massive term you're going to hear constantly is marketable title. What is that? Well, a marketable title is simply one that's free from significant defects or legal disputes. It basically means the property can be transferred to someone else without causing any reasonable concerns about who actually owns the thing. Because let's be real, nobody wants to buy a lawsuit. So we have to verify exactly who owns a property and make sure that title is completely clean by digging into public records. Now, this verification process builds step by step into a timeline. Step 1 is establishing the chain of title. Think of this as the historical chain of ownership transfers, going from one owner to the next. Step 2 is putting all those recorded documents into a single cohesive record, which we call an abstract of title. But here's the catch. An abstract is literally just a history book. It doesn't guarantee the title is actually perfect, because there could be unrecorded issues lurking out there. That brings us to step 3, the opinion of title, where an attorney looks over that abstract and gives their professional assessment. But the ultimate safeguard, that's step 4, title insurance. This is the big one. It provides the actual financial protection for lenders and buyers against any hidden defects or ownership claims that somehow slip through the cracks during the search. Section 2, transferring ownership with deeds, the legal instruments of real estate. So, if title is just this invisible concept of ownership, how do we actually move it around? We use a deed. A deed is the tangible, written legal instrument used to actually convey that ownership. Now, when you're dealing with deeds, you absolutely must distinguish between the grantor and the grantee for your licensing exams. The grantor is the party transferring the ownership. They're the ones giving it away. The grantee is the party receiving that ownership. A really great trick to remember this for test day, words ending in OR usually signify the giver, while words ending in EE signify the receiver. Grantor gives, grantee receives. Of course, for that transfer to legally work, the deed actually has to be valid. And to be valid, it generally needs to check 5 specific boxes. First, it's got to be in writing. Second, it clearly has to identify exactly who the grantor and grantee are. Third, it needs a precise legal description of the property. And no, a regular mailing address doesn't cut it here. It has to be a formal legal description. Fourth, it must include consideration, which just means something of value is being exchanged. And finally, number 5, it has to be signed by the grantor, the person who is actually giving up the property. If you've got all 5 of those things, you've generally got yourself a valid deed. Now, not all deeds are created equal. They actually exist on a spectrum of protection. On one end, you have the quitclaim deed. This offers the absolute lowest amount of protection with 0 warranties or guarantees regarding the title. The grantor is basically just saying, hey, whatever I own, if anything at all, I'm giving to you. On the total opposite end, we have the general warranty deed. This is the gold standard, folks. It gives the greatest possible level of protection to the grantee through a whole series of legal promises regarding the ownership. Definitely pay close attention to this spectrum, because examiners absolutely love to test you on this specific contrast. Section 3. Government and private restrictions. Limitations on your property rights. So if you own a piece of land, can you just use it any way you want? The answer is a hard no. Every single property is subject to limitations. And by the way, just a quick administrative note for your attendance records, your verification code is 6981000. Okay, getting back to it. A super helpful way to remember these government limitations is the acronym PETE, P-E-T-E. This stands for the 4 government powers that restrict your land. P is for police power, which lets the government regulate land use, like your local zoning laws. E is for eminent domain, which is their power to acquire private property for public purposes. T is taxation, the power to collect property taxes. And the last E is for escheat, meaning the state's power to take ownership of a property if someone dies without a will and leaves no legal heirs. Remember P. Now, you want to contrast those big, broad government powers with private restrictions. These actually come from agreements made by private parties, and they include things like deed restrictions, easements, leases, and liens. Let me give you a really specific example from our coursework. Imagine a title examiner is reviewing transaction file number 349852. During the review, they spot a utility easement and a recorded deed restriction. Now, the property can absolutely still be sold, but the new buyer really needs to understand that those private restrictions travel right along with the property, and they'll continue to limit exactly how they can use their own land. Section 4. Property leases and liens, securing debts and obligations. While there are a bunch of different types of private restrictions, let's zoom in specifically on liens. A lien is basically a claim against a property used to secure the payment of a debt. You definitely do not want to mix up their classifications on test day. We've got specific liens and general liens. A specific lien attaches only to one particular, very specific piece of property. Your everyday mortgage is a perfect example of this. It's tied exclusively to that specific house. A general lien, on the other hand, can attach to all the property owned by a debtor, meaning both their real estate and their personal property. A really fascinating dynamic to understand here is the whole concept of lien priority. Basically, if a property goes into foreclosure, who actually gets paid first? Priority dictates the exact order that the available cash is handed out. Superior liens are always paid first. These are the heavy hitters: real estate tax liens, special assessment liens, and federal estate tax liens. Only after those big ones are totally satisfied do we move down to the junior liens, which get paid later based on the order of their filing dates. These include things like your standard mortgage liens, judgment liens, and income tax liens. Grasping this hierarchy is just absolutely crucial for understanding real estate finance and risk. Section 5. Core Chapter Takeaways. Final Exam Prep Review. We've covered a ton of ground today, from the basic nature of ownership to exactly how we transfer it, all the way to the rules that limit it. If you take away just one core concept from this entire explainer, make it this. Title is not a document. Title is the ownership itself, that invisible bundle of legal rights. The deed is just the legal instrument, the vehicle used to actually transfer those rights from a grantor over to a grantee. And finally, no property exists in a vacuum. Every single piece of real estate out there is subject to some form of restriction, whether it's the government's PETE powers or private agreements like easements and liens. I want to leave you with a question to chew on as you continue your exam prep. If title is literally an invisible bundle of rights, and the deed is really just the piece of paper acting as the transfer instrument, how are you going to protect your future clients from the defects they can't even see? Well, the answer lies in everything we just talked about. Doing thorough due diligence, really understanding the chain of title, recognizing just how vital title insurance is, and fully embracing your profound responsibility as a real estate professional. Keep studying hard, keep reviewing these concepts, and I'll see you in the next one.